Good morning and welcome to class number 10 of our firm's 2024 Virtual HOA Condo Academy. We teach these classes in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. And we're very thankful for this partnership. We've had a great run on these classes. We've been teaching them since March of the pandemic in 2020. And we have a lot of people showing up for these classes, as you know. Any of the classes that we have previously taught, you can also find them on our website at mulcahylawfirm.com. There's a wealth of information, and I'm really proud to let you know that we have over 100,000 views on our videos as of right now. So make sure you check those out if you're looking for something, a topic that we maybe aren't covering today. Okay, just some quick introductions. My name is Beth Mulcahy, and I am the managing partner and the senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I've enjoyed working with and representing HOAs and condominiums for almost 28 years. My firm's anniversary is coming up here on November 1st, and I started my firm back November 1st, 1996. Our firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board, and I have for many years. In today's class, we will provide an overview of the new laws impacting HOAs and condominiums. We're going to talk about federal laws pertaining to associations, and we're also going to provide tips on how to prevent crime and limit liability in HOAs and condominiums. As always, we're going to have a question and answer time at the end of this class. And so if you want to ask questions, what you can do is put your questions in the Q&A box on Zoom or the comment section on Facebook Live. And all questions are going to be answered at the end of the session, so likely right at noon. Quick friendly reminder, please limit your questions to one per attendee. Because we have a lot of different people attending here today. Looks like we've got 115 right now and more are joining as we speak. We want to have enough time for all the questions, so we ask you to limit it to one question per attendee. Okay, we launched a poll at the beginning of the session today, and the first question on the poll, thank you so much everybody for participating, is in which city do you reside? So we have just a really great showing today. Every city is represented, it looks like. And so we have 3% from Avondale, 8% from Chandler, 1% from Glendale, 5% from Goodyear, 26% from Mesa, 5% from Peoria, 17% from Phoenix, 20% from Scottsdale, 13% from Surprise, and 2% from Tempe. So, wow, great turnout from all the different cities that we work with. Our second question is, let us know your current role in the association. So 62% of you said that you're board members, 7% are community managers, and 28% are interested homeowners, with 3 in the other category. So really great representation of who's here today, which cities are represented, and then also a strong showing of board members, homeowners, and managers too. So great to have everybody here today. Okay, let's get started out quickly and talk about the Corporate Transparency Act, which is kind of the new law that is federal law that everybody's really talking about in our industry right now. And so as you may be aware, the federal government, United States Congress passed a law called the Corporate Transparency Act, and it applies to 99% of HOAs that are nonprofit corporations. And basically what you have to do is you have to file information about your board of directors and the person who has substantial authority over your association. And you have to do that with the federal government, and there's a special form that you have to fill out, and then you have to download information about each of the board members, like their name, their address, and like a copy of their driver's license or their passport. This law has created a lot of controversy because it was passed by our legislature to counter terrorism efforts and money laundering. And I think we can all agree that the associations, HOAs, and condominiums being included in this is kind of unusual because, it's unlikely that, we're running terrorist activities out of HOAs and condominiums that are nonprofit corporations. But regardless, We are subject to the new law, and we need to file this paperwork by December 31st, 2024. There are multiple efforts, litigation, and legislation underway to exempt community associations from having to comply with the Corporate Transparency Act. But as of right now, it's looking very unlikely that there'll be any CTA, Corporate Transparency Act, exemptions prior to the end of 2024 when this paperwork is due. Therefore, out of an abundance of caution, our firm is recommending that all associations that are set up as nonprofit corporations and that meet the criteria of the CTA, which 99% of you do meet the criteria that you have to comply with it, should make that initial filing before December 31st, 2024. CAI, the Community Associations Institute, is being very active in trying to counter this legislation and make it not required that associations have to comply with it. We're going to be sharing a link with you, if we haven't already, about CAI's efforts to exempt associations from this law. But again, we don't think that it's going to be anything that is going to happen to exempt us from this prior to the filing deadline of December 31st, 2024. So we're telling all of our clients, you do need to comply with this. Okay, I see that one person raised their hand on Zoom. Just put your comments in the comment section on Zoom, and then my office will be able to respond to you, okay? Okay, so we are, just so you know, we've been getting a lot of questions about who helps associations file this paperwork. So my understanding is that some management companies are doing it. Our firm is helping associations with it. We charge a flat fee of $350 per year per entity. And that would include the initial filing and then any changes in your board of directors, because anytime there's a change, you've got to update the federal government of the change through this form. I know that CPAs are doing this as well to help associations. And so there's lots of different places you can go to get help if you have questions on this. If you have any questions and you want to direct them directly to me, you can contact our firm at info@Mulcahy Law Firm, and we can tell you more about the package that we're offering to help associations comply with this. But most important thing to think about is this is not something you can sit on, because it's going to take a little while for the paperwork to be put together. So, we really need associations to be getting us the information if they want us to help them with it by December 1st so that we can comply with the deadline of December 31st. Okay, next topic we're going to talk about this morning is some new laws impacting Arizona HOAs and condominiums. We've been talking extensively about these new laws over the past few months, so I'm not going to spend an exorbitant amount of time today talking about them, but I do want to make sure that you're aware of them. So all of these new Arizona laws just went into effect on September 14th, 2024. There are some quick things that I want to kind of like the most important points of this new law that you need to be aware of. So let's just go through kind of what I think are probably the 10 most important things you need to know. So first things first, if you're a planned community and a condominium, you must now provide a meeting agenda with the meeting notice 48 hours in advance of a board meeting. And you can do that by hand delivery, mail, posting it on the website, email, any other electronic means, using posting it at the community. So the agenda must be provided to the members 48 hours in advance of the meeting, along with the meeting notice. Now, if something changes on the agenda, this happens. You put the agenda out with the notice 48 hours in advance of the meeting, something comes up that's, isn't on the agenda, you can still talk about it at the board meeting. You can get it under new business or old business, or you can add it to the agenda, at that meeting. It's just make best efforts to put everything on the, it's going to be on the agenda 48 hours in advance of the meeting and get it out to the membership. Okay, the next thing we're going to talk about is the ability, number 2 would be the ability of associations to amend their CC&Rs to take out any language that is potentially a fair housing violation. And so, example, this would be sometimes there might be something discriminatory in your CC&Rs that's in there right now, and we can't amend that typically without getting a vote of the membership. So the legislature this year said, if there's something in your documents that violates fair housing laws, the board can remove those provisions in the CC&Rs. It also gives a path for owners if they want to petition the board to, amend the CC&Rs to take out these fair housing laws that violate the fair housing laws, any language in your CC&Rs. There's a path under this new law that you can do that as well. The homeowners can petition the board, and then the board has certain requirements that they have to do. Okay, the third thing that I want to talk about on the new legislation is there have been some minor changes to how we collect assessments after this law went into effect September 14th. The first changes, and this applies to all the three things that we've talked about here so far, have both applied to planned communities and to condominiums. So what are the changes to the assessment collection things that you need to be aware of? Well, first thing is prior to the board filing a foreclosure lawsuit against an owner, the board has to make reasonable efforts to communicate with the owner and offer a reasonable payment plan. So what we're suggesting is that any collection letters that are sent by your management company, your board, or by your attorney have that language in there offering payment plans to the owner. The second part of this law regarding kind of changes for assessments is that associations can now only record a lien for unpaid assessments, late fees that are authorized by the association's documents, and other collection charges, which are usually the charges that your management company is charging. So we can only lien now for those three things: unpaid assessments, late fees if they're authorized in your association's documents, and other collection charges. So what do we do about like attorney's fees and maybe prejudgment interest and self-help charges that maybe in the past we leaned for prior to this new legislation? Basically, we're going to treat those just like we treat fines, and we're going to we can still charge them, but if we want to collect on them, we have to go to justice court if it's under $10,000, or if it's over $10,000, Superior Court, get a judgment against the owner, and then record that judgment with the recorder's office, and it becomes a judgment lien. Kind of the next law, kind of number 4 or 5, if we're loosely, doing the numbers that way, talks about flagpole holders. Our legislature is always passing laws regarding flags, so I think it's important I talk about this. This one only applies to planned communities, but the basic premise of this is that associations can now limit members to 2 wall-mounted flagpole holders. I don't really see that having a widespread impact on associations because I really don't see problems with multiple flagpole holders. But if the board has an issue with that, with the owner in a planned community, we can now limit the member to 2 wall-mounted flagpole holders. Okay, moving on to kind of number 5 would be clarification regarding declarant controls. So there was a law passed this year that specifically talks about when the developer has to leave the property and turn it over to the owner. So I just want you to be aware of that if you're an association that is in transition from developer to owner control. There is a new law that clarifies that the declaration must now provide a date or method of calculating the date of termination of declarant control. So there has to be something in the CC&Rs that talks about, okay, this is when declarant control ends. And then the second part of this is that the association is required to not impede the declarant's ability to develop, construct, and sell its lots. Like if they're trying, like let's say, we have to have something in the CC&Rs that calculates the date of declarant control. And one other part of that I think is important that I mention is that the declarant control terminates not later than the date on which the second to the last lot in the planned community is conveyed to the buyer. So that part is going to potentially trump whatever is in your CC&Rs. Then after the declarant control is over, they put some protections in there so that associations, if the declarant maybe still owns a lot or two, that they still will have some rights as the declarant to, we can't take away their ability to develop, construct, and sell lots. And we also can't take away their ability to use the common areas. So declarant control is kind of like the 5th part of the laws this year. It further defines when declarant control shifts to owner control. Okay, let's talk about condominiums. This one applies only to condominiums, number 6. And it talks about improvements that are made by a condominium owner that may disturb another resident. So the prime example I can think of this is if somebody puts hardwood floors in the second floor condominium and the owner below, obviously that could negatively impact them. So interestingly, what this law says is that if an owner wants to make an improvement or alteration that might disturb its neighbors, the association cannot prohibit it, as long as the owner purchases, installs, and pays for anything reasonable to eliminate or minimize the disturbance. So association boards we're recommending should state in writing what requirements are needed to eliminate or minimize the disturbance when approving these improvements or alterations. And so I know our firm has kind of like a form that we've been giving to condominiums that are worrying about owners putting in hardwood floors. And the form kind of outlines what some noise minimization tactics or materials that can be used to minimize any hardwood floor noise from unit that's on the second floor to the unit below them. If you want a copy of that, you always can reach out to me at info@Mulcahy Law Firm, and we'll give that to you at no charge. Okay, kind of like the seventh new law that I think I would like you to be aware of, there's probably two more here, is that the state government, their state legislature, is now kind of getting involved in two areas that were traditionally areas that cities, towns, and municipalities were regulating. The first area is casitas, ADUs, and guest houses. And basically, the state legislature has made it easier for people to have casitas, ADUs, and guest houses, okay? However, it's important to note that associations can still enforce restrictions in their CC&Rs or in their governing documents regarding casitas, ADUs, and guest houses, despite these new Arizona statutory regulations. So if an owner comes to you and says, hey, I want to put in a guest house, and your CC&Rs say no guest houses, you can enforce that no guest houses provision in your CC&Rs despite the new legislation. Okay, the last law we're going to talk about is chicken coops and chickens. Again, this was typically regulated by cities, towns, municipalities, and the county. Now it is going to be regulated by the Arizona state government. The legislature passed a law saying that municipalities cannot have stricter prohibitions on backyard chickens than specified under Arizona law, and that municipalities cannot prohibit owners of a single-family detached dwelling from maintaining up to 6 chickens. Chicken coops must be enclosed and must meet setback requirements, and if the lot is less than 1 acre in size, the chicken enclosure cannot be higher than the fence line. Roosters are still prohibited, and chicken enclosures must be cleaned twice a week. That'll be very difficult to, regulate, of course. How do you enforce that? But the bottom line here on chickens and chicken coops is that associations can still enforce any restrictions that you may have in your documents that pertain to chickens or, chicken coops or anything that's related to this. But associations can't rely, they need to rely on what the state is saying on this now. So, municipalities, I'm sure, are all updating their code to reflect what state law says, or they're in the process of doing that. So we have to go by what state law is on this now. And the municipalities cannot have a stricter prohibition than what state law says. Okay, we got through a lot of new legislation there. We talked about the Corporate Transparency Act. We talked about kind of 8 or 9 different provisions under Arizona law that have changed since September 14th when the new laws all went into effect. Now let's talk about our main topics for today, which are going to be, we're going to start with federal laws. So basically, in addition to state laws, associations also have some other federal laws that they have to comply with pertaining to associations. And probably one of the biggest laws that we see issues come up with is the Federal Fair Housing Act. And we're going to talk about that in a minute. But first, I want to just do a clarification about whether the Americans with Disabilities Act applies to associations in Arizona. So basically, the Americans with Disabilities Act is a civil rights law that prohibits discrimination in places of public accommodation based upon a disability. Typically, community associations are governed by federal and state fair housing laws and not by the ADA. The only exception to that would be if the association is a place of public accommodation, such as you have a restaurant on site that the general public can access. And so most of our clients, most associations in Arizona are not a place of public accommodation, and therefore the ADA does not apply. That's an important distinction because sometimes the boards will say, well, we're, renovating our clubhouse. Do we have to comply with the Americans with Disabilities Act? I mean, I'm not saying don't do it because I think there are some benefits of, having a bathroom that would be ADA accessible. The question comes in is, do we have to do it? And then that would turn on the fact as to whether or not your clubhouse is a place of public accommodation or not. Most of your clubhouses are not, meaning that you are not allowing the general public to come in. It would have to be, an owners are using it or guests of owners or tenants. Okay, let's talk about the federal law that does apply to our associations, and that is the Federal Fair Housing Act. And basically, just a quick overview of this law is the Civil Rights Act of 1968, along with revisions that were made, and the Fair Housing Amendments Act of 1988 are kind of collectively known as the Fair Housing Act. And the bottom line on the Fair Housing Act is that it prohibits discrimination by an association. It applies to associations based upon a person's race or color, religion, sex, including sexual harassment, national origin, familial status, which means families with children, or disability. And disability is really broadly defined. So it includes persons with mental and physical impairments that substantially limits one or more major life activities. And so let's just kind of break this down. So the bottom line is that associations are subject to this law, whether you're a planned community or a condominium. What is the basic premise of the law is that associations cannot discriminate against these certain protected classes. And the types of classes that are protected, again, are race or color, religion, sex, including sexual harassment, national origin, familial status, which means we can't discriminate against families with children, or a disability. And disability is very broadly defined, but kind of the litmus test is, does this mental or physical impairment substantially limit one or more major life activities of this person? And if so, they are considered disabled. Okay, so how do we, define the different terms that we talk about here? So we talk a little bit about, okay, what's a disability? So we've talked about the fact that it has to be somebody, it could be a mental or physical impairment, and it has to impair somebody's major life activities. Maybe I can give you some examples of things that have come up in my 28-year career of possible fair housing issues that have affected associations. So one that comes to mind is, let's say that an association is a high-rise and they have an elevator, and they decide to pass a rule saying that, any children under the age of 14 must be accompanied by an adult in the elevator. Now, having children myself, I can tell you, I get it. I'm sure what was happening at this particular association is that kids were coming home from school. They were getting in the elevator. They were setting off the fire alarm or whatever, or the emergency alarm. They were stopping the elevator. They're pushing the buttons. And so in good faith, the board was passing this rule saying, okay, children who are under 14 or whatever the age limit was cannot be in the elevator unless they're with an adult. The problem on that is that it discriminated against children because these kids were coming home from school, they weren't with their parents, and they were being forced to walk up the stairs to their units in the condominium, the high-rise condominium. And so how these cases what happens is, so somebody who's aggrieved by a decision that the board makes, what they do is they'll contact the Attorney General's office in Arizona, and they'll fill out a form saying, I'm being discriminated against under the Fair Housing Act. There's online forms that they can use, and then they'll state the reason. So in this particular case, what happened is, whoever the person that was complained about it, the Attorney General's office then sends a letter to the association stating that, please state your side of the story on this. Give us your, what's your position on this. And that's typically when the lawyer for the association is brought in to help the association answer that particular letter that's being sent by the Attorney General's office to the association. And it's smart to have legal representation on that, because once the Attorney General's office opens up the claim, it is serious, and it's expensive to defend these. So you want to make sure that you get some good advice. Now, in that case, what the association ultimately decided to do was to reverse the rule, because it was discriminatory on its face. And if they had tried to keep it, there would have been a lawsuit that was filed. So that's kind of a good example of the families with children. You can, just as a clarifying point, you can have rules about children using the pool unaccompanied, because that's a health or safety factor. Same thing on using the gym in the association. You can require that an adult be present with that person. And that is totally acceptable under the Fair Housing Act. But the elevator was something that they couldn't do that on. Let's talk a little bit about some other things that we see. I've had a couple situations where, under the Fair Housing Act, where we'll have an owner who receives a violation letter from the association, and they push back to the association after they get the violation letter. I feel that I'm being discriminated against because, and it's basically, they're threatening that we're violating the Fair Housing Act. Just a little piece of advice for boards that encounter that situation. Whenever you have an owner or a tenant who is saying, I feel that I'm being discriminated against, that is something that, in my opinion, you should fast track that to your attorney and talk about that situation with your attorney. I'm to be perfectly honest with you, like 90% of the time when somebody claims to the association they feel they're being discriminated against, we'll take a look at it, and ultimately we'll say, well, we sent you a violation regarding, your trash cans being out or your yard not being maintained. And we had no idea that you were, of French national origin, and so, whatever, and so sometimes they're making false allegations of harassment or discrimination. And so the best advice I can give you is, when this occurs, when someone in your association is claiming they're being discriminated against, you should talk about it with your attorney, number one, and you should strategize. Is this a valid claim? Is this not a valid claim? And then respond back. You don't want to leave something like that to fester. We want to have a well-reasoned response back to the owner, and just state the facts. If we're not discriminating against them, which, like I said, it's very rare that I would ever see something like that. We just state that, hey, we treat everybody the same. We noticed the trash can being out, and here's a picture of it, and we sent violation letters to everybody who had trash cans out that day, etc. A couple of things. So those are two examples of discrimination against, families with children, and then maybe one of national origin. Let's talk a little bit about, accommodations and modifications that an owner might be requesting because they're disabled. So, as I said previously, disability is kind of hard sometimes to see. So occasionally you'll get a request from an owner, like for something pertaining to your association. And let's say that a good example would be like a pet, an emotional support pet is the perfect example. So some condominiums and some townhomes sometimes will have a restriction in their documents that says, you can't have a certain pet, or you can only have one pet and they want two, or you can only have a pet that's 20 pounds and they want a pet that's 80 pounds. And so the common time that we see this come up is, let's say that person wants to have a pet that's not approved by your association's documents. And so they will come to you as the board, and they will make a request for a reasonable accommodation. And that is typically an alteration or a variance to whatever the association's documents say. So maybe the documents say no pets, or maybe the documents say you can have a small pet that's 20 pounds or less. But the owner comes to the association and says, we're asking for an accommodation. So can you give us a variance to your documents to provide me as the disabled person with equal use and enjoyment of my home. And, so what they're asking for is a reasonable accommodation. So we typically see this with, like I said, condominiums and townhomes more. So even if a community association has a no pet policy or has a weight limitation on pets and they want a pet that's heavier than the weight limitation, an occupant, it could be a tenant or it could be an owner, or it could be a guest of an owner, they may be permitted to keep an animal as a reasonable accommodation under the Fair Housing Act. But in order to be able to qualify for an assistance animal and get that reasonable accommodation, which means like a variance, the 3 factors must be met. So number 1, the person must have a disability. And like I said earlier, that's really broadly defined. The second thing is the assistance animal must serve a function related to the person's disability. And then number 3, the request to have the assistance animal must be reasonable. Disabled residents, it's obviously it can be easier to tell if you have like a sight dog or a dog for somebody who is hearing impaired. Disabled residents can request an accommodation for most type of animals for non-emotional support. To comply with the Fair Housing Act, the association can require the resident to provide a few things. So related to the disability, we can ask them to provide proof of the claimed disability from a physician, unless the disability is obvious, like they have a white cane, that's like obviously that they're blind, apparent or already known to the association. So something that we can ask for as the association is we can ask for proof of the claimed disability from the physician. And we can require a physician's statement that the animal is necessary to meet the resident's disability. And we can require the resident to follow policies for the cleanup of animal waste, leash requirements, etc., noise requirements in the association. And so if somebody's asking for an emotional support pet, or if they actually have a disability and they need a pet to support that disability, we can still make an exception and grant variance. However, there's a process that's usually followed. So we usually ask for more information. We ask for the proof of the claimed disability in the form of a letter from their physician. We ask the physician to, link together why it's necessary for the resident's disability to have the support animal. And then we can make the resident, comply with the requirements to, pick up after your dog, make sure the dog's not barking and creating a nuisance in the association, etc. There is a great article that was put out by CAI, the Community Associations Institute, on recognizing and understanding service and assistance animals in community associations. And we're going to be sharing that with you shortly on Zoom and Facebook Live. That's just a great little resource if you want to do, more research on this. And there's different kinds of animals, too, that you need to be aware of. There's service animals that are specifically trained to work or perform tasks for individuals with disabilities. Therapy animals that provide psychological or physiological benefit to individuals or groups in a clinical environment, and then emotional support animals, which provide comfort for people with disabilities. Another example of a reasonable accommodation, so would be like a variance to the association's rules, is when we talk about group homes. So this is often something that clients are really surprised to hear about when they'll contact me and they'll say, we just found out that there's a group home in our neighborhood, and we think this violates the business prohibition in our CC&Rs. And so group homes actually are an exception under the Fair Housing Act. And the Fair Housing Act amendments of 1988 expanded protections for individuals with all types of disabilities, thus banning the prohibition of group homes. So a group home is considered a group of unrelated disabled individuals living together in a dwelling in a community association. If you find out that there's a group home in your neighborhood and they haven't already told you about it, here's some things that you can do. You can request documentation from the group home operator or the owner that verifies the existence of the disability related that would cause the need for the variance or the reasonable accommodation. So, even though the thing that clients sometimes find hard to understand is, hey, this is a business. They're making money out of this home. And our CC&Rs say no businesses can be run out of the home. Well, this is a special carved out exception under federal law. So group homes are allowable under federal law. We can't do anything about it, even though our CC&Rs may say you can't be running a business out of your home. What we can do is we can do a couple things. So first, if it is in fact a group home, it should be registered with the city, municipality, or county that you're residing in. And so you can contact the city, town, municipality, county, and make sure that they have the proper licenses to be a group home. 99% of the time they've already done that and they do have the license. Some cities, towns, and municipalities and counties have a restriction as to how many group homes can be in any one clustered area. So you may want to check to make sure that they are in compliance with that. There are some, differentials between what's a legitimate group home and what's not a legitimate group home. So asking them for the documentation regarding what is the purpose or what is the disability related need for the variance. It could be possible that they're operating a group home that doesn't fall under the Fair Housing Act. The most common ones that we see are group home for the elderly, group home for the disabled, maybe that can't live on their own, group homes for recovering alcoholics, group homes for people that may have cognitive or mental disabilities. Those are all the types of group homes that would be covered under the Fair Housing Act, and we'd have to allow them. Some group homes that would not be allowable, here are some examples. So current addicts or substance abusers, current alcoholics, criminals, those with bad credit, sex offenders, those would be the ones that are not going to fall under the category of a group home under the Fair Housing Act. So you could prohibit those type of group homes. But in my experience, most, like 99% of the group homes that come into an HOA or a community association, they are going to be ones that are covered under the Fair Housing Act. Again, the association can make this group home comply with everything else that any other owner would be required to. So they have to abide by all the parking restrictions. They have to maintain the buildings. They have to maintain the landscaping. They can't make architectural changes without getting approval. Lots of times they try to architecturally alter the garage to make more rooms for the group home. And if, that may be something that's not allowed under your documents. They also can't have, excess noise or be creating nuisances. It's basically just needs to be treated just like any other home in the association. Now, kind of one thing I want to mention about, group homes is oftentimes clients will contact me and be really upset about a group home moving into their neighborhood because they think it's going to affect their property values, or it's going to create all these extra problems with parking and noise. In my experience of 28 years of doing this, I do not think that I've ever had a group home that has been a problem in the neighborhood, even with parking. And so I just want to mention that has not been our experience. They've generally been good neighbors. They pay on time. Occasionally there's a parking snafu, but usually it's worked out pretty quickly. The trash cans are in and out at the right time. So if this is happening to your community, I understand you don't necessarily want that because it's not the use that you thought was going to be, your neighbor per se, but they end up being really great neighbors is what my experience has been. And you honestly can't tell that there's anything different with that house. That's been my experience working with so many different associations over many years. Okay, let's give one more example of what would be like a reasonable modification. So remember, under the Fair Housing Act, if somebody wants a reasonable accommodation, we've talked about a couple different examples of that, like the emotional support pets and the group homes would be a great, example of a reasonable accommodation that we're required to make under the Fair Housing Act. Let's give an example of a reasonable modification. So let's say that somebody is in a wheelchair and they want to use the pool, but the pool at the association doesn't have a pool lift to get the person in and out of the pool. And so the disabled person who's in a wheelchair comes to the board and says, I would like to have a pool lift installed at the association's common area pool. Okay, so how does that work? So basically, if an owner is requesting a modification like this, the modification should be paid by the disabled resident unless the association gratuitously agrees to pay for it themselves. So it's not like the association has to, shell out 10 grand for a new wheelchair lift at the pool. And that is exactly how much that costs, by the way. I just had that at my board meeting last month, where we had a request to put it in there. So it's about 10 grand, to put one of those in. So just some important things to remember. If the owner is asking for a modification to the common areas, we typically will have to allow it. When you approve it, make sure that you talk about maintenance and what will happen if that owner moves out. How will that maintenance be shifted, or will they remove it from the pool? All of these things need to be pre-thought out, because if they move and that lift's there, then, maybe we are going to be required to maintain it or replace it if it breaks. So we want to plan that out in advance. Again, the owner is required to pay the cost for that. And this kind of same analysis will go for like mailboxes at the association. If somebody wants a cut curb, the association would be required to allow that so the person could wheel up to the mailboxes. Now, in my experience, a small expense like that, the board's just going to do it and pay for it, but they're not required to. So those are some good examples of, a reasonable modification that the association would be required to make under the Fair Housing Act. Okay, let's talk a little bit about housing for older persons, which is like the 55 and plus, requirement for certain associations. So you may be driving around the valley at different times, and you may see a sign that says active adult community or 55 plus community. And, how does that work under the Fair Housing Act? So there is an exception or an exemption under the Fair Housing Act that talks about, it allows an association or communities to restrict people who occupy homes or lots or units, if it's a condo, based upon age. So there's a carve out. Remember, we said initially when we were talking about the Fair Housing Act, like, okay, we can't discriminate against, families with children. Well, in this case, you can. There's a carve out for 55 and over communities. And basically what it is it says that certain requirements have to be followed to be characterized as a 55 plus community. The 55 plus community must maintain at least 80% of the occupied units with at least one person who's 55 years of age or older living in that unit. So they don't have to be the owner, but they just have to be occupying the unit. One person occupying the unit has to be age 55 or over. They can live with somebody who, is 48, but one person in each unit, in 80% of the units in the association would need to be 55 or over to have us be called a 55 and over community. The second requirement is that the association must publicize and adhere to policies that demonstrate the intent to be housing for older persons. And third, the association must comply with the rules for verification of occupancy every 2 years. So what we recommend to associations is have a census every 2 years, or be really vigilant about who's living in the units or the lots, and update it at each time there's a change in ownership, or there's a change in occupancy, or a change maybe in the renter that's residing there. So associations that are 55 and over communities, they have some special requirements so that they can keep that 55 and over status. And definitely one of them is you got to have good record keeping, so that if you're audited by, or there's a lawsuit on this, that you can show very clearly that 80% of your lots or units have one occupant in there that's 55 or older. Okay, one thing I just want to mention real quick is kind of a newer thing about potential liability for associations if there's harassment in your association. And so maybe an example of this would be, let's say you've got two neighbors who are fighting, and one of the neighbors maybe is a protected class. Like, let's say one of the neighbors is, a protected class under the Fair Housing Act. So let's say maybe you have a family that is from a different national origin, or maybe it's an African American family that's living in one unit and they feel they're being discriminated against by the other unit. And so normally in an association, what we'll say is, well, that's really an owner to owner issue. We're not going to get involved in that. However, a recent trend in case law for associations, and also, fair housing laws are amended from time to time. Recent amendments indicate that, hey, the association has potential liability if they're aware of harassment between, of an owner and the association, or an occupant or a resident or tenant, based upon that person's race, color, religion, national origin, sex, familial status, even if it's families with children, or disability if they're disabled. So we have to really keep our radar out about this. Normally we would say homeowner to homeowner dispute, hey, we're not getting involved. That's Hatfields versus McCoy's. But if there's an element of a fair housing violation, we may need to take a look at it. If that occurs, I really recommend that you reach out to your legal team, your law firm that you work with, or our firm, and talk with us about it. And we can strategize as to how and if we should get involved in the matter. Typically, if there is harassment between, these two owners or two residents, we will send a letter to both of them saying that we received a complaint on this, and that if this is true, this is unacceptable behavior. And, make sure that we inform both sides of their respective rights. They can get a lawyer, they can go get an injunction prohibiting harassment from justice court. Basically, we're just papering our file to make sure that we've done something. You want to talk that through with your attorney. It could get to the point where we have to do more than that if it continues. But in my experience, usually that kind of puts an end to it, and it's no longer an issue in the association anymore once we send that communication. Occasionally, I have seen it escalate, and we do, potentially have to, file a lawsuit on something like this, but that would be very rare. Like maybe one time in 28 years have I seen us having to do that. Okay, so that pretty much covers everything that I wanted to discuss regarding the Fair Housing Act. Just some quick reminders before we move on to our next subject. Be careful. When owners are saying, I'm being discriminated against, or residents, tenants, that is something where the association's antenna should go up, and the board's antenna should go up. And you need to be talking about that with your legal counsel to determine what, if anything, we should be doing to make sure that we're protecting the association and that we're not treating somebody differently under the Fair Housing Act, because these cases can be very expensive. If the Attorney General gets involved and they send us, a complaint regarding this, it's probably going to be somewhere between $5,000, $10,000, $15,000 in legal fees to defend that, even if it's frivolous. So we want to nip things like that in the bud right away, and make sure that we're getting advice and addressing it in the most proactive way possible. The second thing that I would, advise you on is when you get these, requests to make changes to the common areas, or requests to make a change to somebody's lot, you want to make sure you're talking to your attorney too, because let's say that somebody has a stroke and they want to put a ramp at the front door of their home to get into it when they come home from the rehabilitation center. And maybe associations don't want to allow that. Well, under the Fair Housing Act, we probably do have to make, an accommodation on that, or we don't have to pay for it, but that's something that we probably can't prohibit under the Fair Housing Act. So we want to be really careful whenever we get unusual situations about modifying the common areas or someone's lot, or requests to accommodate based upon any of these protected classes. We want to escalate it to our attorney and talk it through if we're going to deny it. Okay, so that's kind of just the quick 411 on the Fair Housing Act. Surprisingly, we have issues on this every single month. I mean, this is something that comes up in associations all the time. So I thought it was really important that we address it in one of these classes. Okay, let's talk next about preventing crime and limiting liability in HOAs and condos. So kind of interesting, over the past few years, we've been getting more and more questions about, hey, what kind of liability does our association have if there is a shooting in the common areas, or there's a string of robberies, or someone's coming through at night and breaking windows on car doors to get, access to the laptop on the front seat in the car. Or even more recently, I think probably some of you saw this on the news or in the newspaper, there was a wave of crime sprees in certain parts of the valley by, some foreign cartels, I guess you could call them, that were coming in and basically pinpointing homes, robbing them in a certain neighborhood. And it was becoming so troublesome that different cities, towns, and municipalities were establishing task force to get the word out and to, educate owners about things they needed to be doing to protect themselves. So preventing crime and limiting liability is, for an association, if there is crime in your association, are issues that may not come up often, but they're issues that you need to be aware of. And I think we can all agree that there has been more crime in the past decade than probably we saw in the previous decade. And so it's important for all of us to be vigilant and to, kind of come up with, okay, what do we need to know as a board if we're facing this situation? So interestingly enough, there was a case in Arizona decided earlier in my career. Gosh, it must have been like late 1990s. And this case was the MARTINEZ versus WOODMAR case. And the reason why I'm talking about this case is because it directly impacts the way that associations can be held liable if there's a crime happens in their particular association. So what happened in this case is kind of interesting facts. The plaintiff, who is the person who is suing the association, this was actual lawsuit, this is reported decision, was attending a graduation party at this particular condominium complex. And the plaintiff was a guest of the tenant in the condominium complex. So we've got a guest who's coming to a graduation party at, a tenant's property. Basically what happened is the party went on, and later in the evening, the plaintiff, who again is suing the association in this case, and two other guests came back to the complex's parking lot. So they're in the condominium's parking lot, and they found a group of local, young people sitting in one of the guests' cars. And, there was an altercation because it wasn't their car. They were sitting in it. And there was an altercation between, the plaintiff and this group of kids who was there. And the plaintiff was ultimately shot in the back. And the plaintiff, his friends, and the live-in security officer recognized the gang as a group of gangs, a gang from a local complex. And they would often gather in the association's parking lot and engage in illegal activities like drug dealing and underage drinking and, all kinds of different things. They were basically, not authorized to be there, and they're engaging in illegal activities. In the past, what this association had done is they had a full-time security guard who would, monitor the parking lot, break up the gang from coming in there, and kind of avert any problems in the association. However, due to some budget constraints in the association, they decided to only have the security guard patrolling limited evening and early morning hours. And it was kind of irregular, and it wasn't like it had been. We had, full-time security guard previously, but because we didn't have enough money at this association, and this is not my client, I just am reading about this case after the fact, but we lowered our security at our association, even though we knew that, hey, there was this gang activity and there was legal activities in our parking lot. We just couldn't afford it. So basically what happened is the plaintiff sued the association, claiming that the association was liable for failing to prevent an attack. And the case, went all the way up to the Arizona Supreme Court. And basically what they found was that the association didn't have any authority or responsibility to control the shooter. Okay, so that was good. But the bad part is that a duty existed on the part of the association with respect to the property. And the court held that with respect to the common areas in this particular condominium association that were under the association's exclusive control, the condominium association had the same duties as a landlord would have to a tenant. And so the association in this case found the association was liable to the plaintiff who was shot because it found evidence that the association knew that the gangs gathered in the parking lot and other common areas, knew that the gang was engaging in criminal activity, and was warned by its own security guard of the need for a 24-hour patrol. And then they did hire that security guard for 24-hour patrol, but then later terminated him because of expenses. And, they made a bad choice. And basically what the MARTINEZ case, said is, okay, association, you're going to be held liable here for this shooting because we need to be held at the same standard of care as the landlord. And because we controlled that common area land and we made a choice not to have a full-time security guard there 24 hours, which was needed because of all the dangerous activities on the common areas, you're going to be held liable. And we had an affirmative obligation to exercise reasonable care to inspect and repair such parts of the premises for the protection of this particular plaintiff and all owners and all residents and guests of residents in the association and tenants. And that duty extends also to members of the tenant's family, his employees, his invitees, his guests, and others on the land in the right of the tenant. So, the duty here that this association had extended beyond, the unit owners. Of course, we had a duty to the people that own there, but it also expanded to anybody who's on our land with the consent of an owner or a tenant in the association. So, because the association failed to maintain the common areas safely, and it was foreseeable and preventable that this would have happened, they had a duty to the association and therefore should be held liable. So this is kind of a scary case for associations, right? Because, think about it. We, as the association, hears about things that are happening in communities all the time, right? Hey, my car was broken into, or, our house was broken into, or we left our garage door open and someone ran off with our golf clubs. How far does this case go to make associations have to have security guards? And talk about bad timing, right? No association that I work with has extra money hanging around for security guards. So this case is problematic, right? And so if you're in a situation like this as an association and you have issues that are facing your association for, you're hearing about crime in your community, or break-ins, or cars, being stolen, or there's actual gangs that are, doing drive-by shootings or something like this, you really need to be thinking about what are some practical suggestions, active things that your board can be doing to limit liability. Now, what this association could have done here, this MARTINEZ or WOODMAR condominiums could have done is maybe they could have set up a block watch. There's a lot of different things that they could have done to limit their liability. And we have a really great cheat sheet that we're going to be sharing with you now that goes through all kinds of suggestions that we have to help your association limit liability. We have on-site suggestions like putting in a guard gate or electronic gates. No, that's expensive, but that's, something that could be done. You could have a security patrol that's created for your association, or a block watch. You could have cameras installed. You may need to improve your lighting in the common areas. But picking these type of on-site suggestions are, a good idea for associations. We also have information about programs and information that your association can use to help you if you're in a situation where you have potentially dangerous activities happening in your common areas, or crime happening in your common areas. And so all these are listed on our cheat sheet that we're going to be sharing with you, and you can go through them. It's about 2 pages of recommendations. So the key thing that I'm going to leave you with on this topic is, here are my best suggestions for you as board members. Don't misrepresent the level of security that you have in your association. Be honest with the owners. If you can only afford to have security, random nights, maybe sometimes you pick random nights so that people don't know, if there's a problem with teens in your community that are wreaking havoc at your pool. You don't want to tell them, oh, we only have a guard on Thursday, Friday, and Saturday night. You can just let them know we do have a guard several nights a week. We have, surveillance cameras that maybe aren't manned, but we, do have cameras on the common areas in case an incident happens, we can go back and look at it. I go to a lot of annual meetings, and I often find a police officer there, and the police officer is giving tips on how to prevent, crime in your association. They often come at no charge, and they just give a summary of what's happened in your neighborhood over the past year and what type of criminal activities have happened, and what are some things that you can do to prevent it. Also, just remember that off-duty police officers are often hired by associations to keep the peace at board meetings or annual meetings if there's serious problems. They also do patrols through the neighborhood. You have to pay them. Usually it's a minimum of 6 hours, but that's a really good resource for you to have somebody who's very familiar with your community. You're paying them as a second job for them, and they take a special interest in your community. If a problem occurs in your association, another suggestion for you, reach out to your trusted advisors, your attorney, and talk about, okay, what can we do to counter this, to limit our liability? Should we notify the owners that this happened and remind them to keep their garage doors closed? Should we think about increasing our security? Should we think about putting in cameras? Is our lighting adequate? Should our landscaping be trimmed back, etc.? Another important thing is make sure that you have adequate insurance, because in this particular case, the judgment that was ultimately rendered against the condominium association was very hefty. So you want to make sure that you talk about this issue with your insurance agent and make sure that any policy that you have would be covered under, a scenario like this. So you want to have directors and officers insurance, and then also premises liability insurance that would cover any security things that could happen on your property. So then in the event you're sued, you'll have adequate coverage. Last but not least, remember, don't reduce security without communicating with your owners what's going on and why you're reducing it, and what are some pivots that everybody can do to keep themselves safe. So again, this is a great cheat sheet. I really encourage you to take a look at that to help your association navigate, if you're having issues with crime in your community, or burglaries or theft or whatever it is, vandalism. These are all some great suggestions on this cheat sheet to help you navigate that and limit your liability as a board. Okay, here's some conclusions from today. We had just a really great turnout, so thank you everybody for being here today. We are really looking forward to joining us on our firm's 28th birthday. We're going to have a little birthday party on Friday, November 1st, where we are going to be having our firm's first Friday free call-in, which is virtual. And that's actually 28 years to the day I started my firm, which is kind of crazy. I'm actually going to tell the story of the day that I started my firm. It's pretty funny, actually. We'll save that for when we log on First Fridays. That's going to be our firm's live virtual First Friday event on Friday, November 1st at 9 a.m. If you're not familiar with live virtual First Fridays, this is a monthly event, live question and answer session, where we hop on and we answer your question for free. Every association can ask one question, and we will answer it. And we just go through it rapid fire, just like we did the questions here today. Also, we want to remind you that class number 11, our November class of the 2024 Virtual HOA Condo Academy, is going to be held on Tuesday, November 19th at 11 a.m. And the topic for that class is going to be solutions for rental properties and parking headaches. So we're going to talk about how to best handle rental properties, including a discussion on short-term rentals and how to best manage those, and parking issues. And as always, we're going to have a free question and answer session at the end of the class. Note, our November class will be our last Tuesday session of 2024. So we always have our neighborhood services classes the third Tuesday of every month at 11 a.m. In December, we take a hiatus, and instead we combine our December class, because of the holidays, with our First Friday. So our December First Friday event will also be our December neighborhood services event, and typically we log on and answer all of your questions. And we kind of give a little overview of what's going to be happening in 2025 as well. So thank you so much for being here with us today. Appreciate you being here. We had a great turnout today. Look forward to seeing you on November 1st. And if you have any questions, you're always welcome to reach out to our firm. Take care, everybody, and have a great rest of the week.